Cochran, Mr. Neufeld, Mr. Scheck, Mr. Blazier, people represented by Ms. Clark, Mr. Goldberg, Ms. Lewis. Jury is not present. Counsel, the record should reflect that on Friday evening, August the 18th, the court, in the presence of counsel, Mr. Douglas, Mr. Scheck, Mr. Neufeld for the defense, and Mr. Hodgman and Mr. Yokelson and Mr. Fairtlow on behalf of the prosecution, in the company of the investigating officers, went to the Bundy crime scene to determine whether or not the conditions were satisfactorily adjusted so that they were substantially similar to the conditions as they were on June the 12th, 1994. And after approximately an hour at the crime scene on Friday evening, after extensive discussion, comparison of photographs, modification of lighting, etc., the prosecution chose to withdraw their request for a crime scene view at nighttime, and as a result, the court canceled the viewing that was scheduled for Sunday evening, August the 20th, and that's my recollection of what occurred. Any comment as to that particular issue? Submitted. I just wanted the record to reflect our activities of Friday evening.
Just so the record is clear that the court made every effort to substantially replicate what occurred, and the critical factor was a light that was near the gate where the body of Nicole Brown Simpson lay. And once that had been repaired, the decision was made.
All right. The problem being is that the photographs really didn't give us a clear angle or clear appreciation of the angle of that light. And as we discussed on the record last week, photographs are dependent upon the speed of the film, the aperture, the exposure, and so it's hard to, from the photographs themselves, recreate the lighting conditions as they existed that evening. And so there was a defense objection to begin with, and then the prosecution withdrew their request. All right, Mr. Scheck, anything else on that issue?
Yes, I think that, but the court's concern that the lighting be restored as much as possible to the condition as it was that day was a wise one, because when we did do that, I think it was clear to all parties that there was substantially more illumination on our visit last Friday evening than there was the previous visit. And that was more in keeping with what is depicted in the photograph taken that evening by the police.
Well, you objected, you won, so I guess there's nothing much more to say, is there?
No, I just
All
wanted
right.
to make the facts clear.
All right. Any comment on that issue on behalf of the people?
Only, Your Honor, briefly, that the neighbor who lived next door to Ms. Brown indicated that the lighting as it existed on this past Friday night was considerably brighter than it had been on the night of June the 12th. And he said, according to his memory, that it was not representative. Detective Lang similarly indicated that the lighting no longer represented its condition, that it was considerably brighter on Friday night than it had been.
All right, since the court could not substantially recreate the conditions, then I think this is the appropriate decision. All right, this morning, the court directed counsel to confer with regard to the next witness, defense witnesses, who is Mr. Regals, is my understanding. And Mr. Goldberg, you're handling that matter?
Yes, Your Honor.
All right, did you have the opportunity to speak with Mr. Blazier and Mr. Regals and discuss the matters you needed to address?
Yes, I did. I wanted to address a couple matters before the court, before we started, if I may do so.
Yes.
Number one, Your Honor, Mr. Blazier, I believe, and maybe it was a miscommunication, had told me that Mr. Regal was not going to be testifying to anything that related to the notes that they turned over within the last couple of weeks in discovery. And I believe...
What was the subject matter of Mr. Ragel's notes?
Well, they covered a wide range of topics. The only one that's relevant for what I'm about to say is notes as to the August 26, 94 Bronco search, which, and Mr. Blazer could probably give us. There are some August the 26, 94 Bronco notes, and then I believe there's another little sketch that was provided from a viewing in April of the Bronco.
April 95?
Yes, Your Honor, of this year. And I did not know that he was going to testify to that because of the, excuse me, it looks like the date on that is March 14th of 95. I did not know he was going to testify about these things because Mr. Blazer seemed to indicate to me that he was only going to be talking about things that had to do other than the notes. So there has been, without any question, a discovery violation here, in my view. I mean, these notes are old and they were just turned over to us very recently. However, I don't think that I can say in good faith that these particular matters, as I understand Mr. Blazer's offer of proof this morning, would require a delay as the sanction, and therefore I'm not requesting that because Mr. Blazer has represented to me that the only thing about the Bronco that Mr. Ragel is going to be testifying to is whether or not he could see certain stains on the door. And if that is true, I can't legitimately say that I need more time to prepare on that particular issue if that is all his testimony is confined to. However, we would be requesting a sanction for the discovery violation in the way of a juror admonition. And this just came to my attention this morning, so I didn't know that I was going to be addressing Your Honor on this. The second issue is as to the scope of Mr. Ragel's testimony. The people have previously argued to the court in a number of different contexts, citing the Supreme Court case of People versus Koresh at 52 Cal 3rd, 648. In fact, I think I discussed it a little bit last week in another context with respect to Michelle Kessler. The language saying that we agree that it was not material to any issue in this case. The defectiveness of the evidence gathering techniques in this case, if any, is not measured in comparison to other purportedly superior techniques. In other words, that the issue when we're talking about forensic evidence and evidence gathering techniques is what techniques were used. Were those techniques defective in any way so as to undermine the probative value of the evidence? Looking at other techniques that could have been used or other hypotheticals as to how someone else would have gone about investigating a crime scene, while it may be interesting, does not, in the words of the Supreme Court, assist the jury in determining to what extent the method employed actually produced probative elements, nor can it help the jury assign a weight to the evidence. My understanding of Mr. Ragel's testimony is that he wants to testify to how the crime scene should have been processed, techniques that should have been used, techniques that he's critical of, and so on. And I just think that that kind of wide-ranging inquiry into the overall competence of the crime scene investigation is not probative in light of this language, unless it is limited and tied to specifically what effect this could have had on the evidence that we actually have produced in this trial. And I don't think that that is the intent from my conversation with Mr. Ragel of this testimony. I don't think that he's intending, if I'm understanding what he told me, to say, okay, the effect of this is that now the DNA results are less reliable because of the following. Because he is not an expert in DNA analysis. So just to say, well, I don't like the way that they collected it without being able to tie it to an effect, in my view, and I think in the California Supreme Court's view, is not probative and should not be allowed. So there should be at least some strict limitation on his testimony if not out-and-out preclusion of his testimony, depending on exactly how they want to structure the testimony.
Mr. Glazier?
Good morning, Your Honor. Let me first talk about the purported discovery violation. This is a one-page, actually half-a-page handwritten note of about the Bronco when they went out there in March to look at it. There were no testing done. Mr. Regal did nothing except look. This is not discoverable under Hines or any of the other cases. He doesn't intend to rely on this particular note. All he's going to testify about is that the specks that Dennis Fung identified as the specks of blood that Mark Furman described can't be seen, or most of them can't be seen unless the door is open. That's the total of his testimony on that point. This note is not even discoverable. It's I think it was given to them last week anyway. It's less than half a page. As to his testimony in general, they have presented through all their witnesses opinions as to whether these crime scenes were processed appropriately or competently. All Mr. Regal is here to do is to testify as an expert on crime scene processing techniques, to testify as to whether the techniques used in this case were acceptable or not, were competent or not. That's all. It's rebutting the opinions given by all of their witnesses about the appropriateness of the way they did certain things. Obviously, if he testifies that it's inappropriate to put wet swatches in a plastic envelope, it's difficult to express that without expressing what's the right way. How are you supposed to do it? What do you need to do to protect the evidence, to protect the integrity of the evidence? I don't intend to spend a lot of time on techniques that weren't used in this case. His primary focus of his testimony is the techniques that were used in this case and whether they were acceptable or not from a forensic or investigative standpoint.
Well, to respond to the last issue first, it may be possible that the court simply has to rule on a question-by-question basis as to Mr. Regal's, the propriety of Mr. Regal's answers. Because I would agree with counsel that at least in the one hypothetical example that he gave, if he's saying, is it proper to put items in a plastic bag and what kind of effect that could have, that probably would be a proper subject of testimony. But then if you ask the next question, well, what other techniques can be used, it may or may not be crossing the boundary into the territory that I think Koresh prohibits. So maybe this is more in the nature of simply trying to state what our position is up front, and maybe Your Honor does simply have to rule on a question-by-question basis on those kinds of issues.
All right.
As to the discovery violation, if I may, Your Honor, and I'm sorry because I did not know this issue was going to come up until literally a few minutes prior to addressing it in court. But on this one page, it is, as counsel represented, a page indicating his observations, and there's what purports to be a little sketch of the Bronco on it. So it clearly is a report of observations of experts that's discoverable. What I should have brought to the court's attention that I failed to is that this also indicates that there were 12 photos and they have photographic numbers. And I seem to recall that when this occurred, Mr. Regal did take photographs, and I don't have the photographs of this. So the photographs are a form of documentation of an expert, of an observation of
Excuse me, Mr.
evidence.
Goldberg, were you present for this
Yes.
viewing with Mr. Regal?
And I had no idea what they were up to. I mean, you have to, it's difficult to get into the conspiracy mode sometimes to figure out what's going on, because they were looking at little cracks in doors. So I just thought, yeah, these guys are Meshuggah, and didn't know what they were up to. So I wasn't particularly watching that carefully what they were observing. But at any rate, Your Honor, what? Well, this is Los Angeles. It's an LA pronunciation.
Yeah, but somebody who's a Goldberg, Mr. Goldberg.
Yeah, well.
But having grown up in the Los Feliz district, I've heard that expression before.
Okay. At any rate, Your Honor, I don't have the photographs, and I think we're entitled to them.
Well, we don't intend to use any of those photographs, so
But
it's not
there's
entitled to
still
them.
documentation of what was done.
At the same time, there are several police officers there. They're taking any pictures they wanted.
All right. I believe, as Mr. Goldberg indicated in his last comment, that the issue of whether or not Mr. Ragel's testimony will go into other techniques and how far the court will allow is really a question-by-question, issue-by-issue, subject-by-subject determination the court has to make. So I take that as simply that the prosecution wants the court to be on notice to expect those issues as they come up. I take that as a premature objection. As to the purported discovery violation, I find no violation since the prosecution was, in fact, present at the time these observations were made. They had equal access to those observations. They could have taken their own photographs. They do have the notes and plenty of time to prepare for cross-examination of Mr. Ragel's. None of this is, to my recollection, going to be rocket science. So I think we can proceed. All right. Lastly, counsel, I spent some time over the weekend dealing with the offer of proof regarding the Furman tapes, so-called, and I had great difficulty dealing with it. And Mr. Cochran, do you want to address that issue?
Yes, I will, Your Honor.
Tell me what to expect.
Yes, let me tell you what to expect. And I apologize to the court. As the court knows, I was out of town. And I'm not totally sure what Your Honor has. Did Your Honor receive a redacted copy of the original tapes turned over by Messrs. Schwartz and Regwan? Is that correct? And I understand that Your Honor was not given the first 48 pages. Is that correct?
Apparently,
Of the transcript?
something was given to me this morning.
Yeah, I brought that down for you this morning. And let me see if I can explain the confusion and tell you where we are and how we straighten it out. Of course, the court is aware that we over-optimistically said we'd be able to get you a verbatim, word-for-word transcript of this pretty quickly. That is now finished. And by the end of the day, Mr. Douglas will walk through those doors with hopefully a redacted, verbatim transcript and an offer of proof that's key to our transcript. With regard to Ms. McKinney's transcript, some of the pages are off. We had discovered this in North Carolina. Also, as the court is aware, the first tape had been taped over, and she had the first 48 pages. Apparently, you hadn't been given, and I discovered that last night when I returned, and I gave those to Your Honor's clerk this morning.
Well, I spent several hours this weekend. At first, it was so incoherent, I couldn't figure out what was going on. But I figured since time was of the essence, I ought to at least try to make some sense of it.
Sure.
And after going through your offer of proof, trying to correlate it with the tape and with the transcript, I couldn't do it. And I don't think it's my obligation to spend my time going through 12 hours of tapes looking for a particular excerpt.
It certainly isn't. These items are on those tapes. It's important that you be able to hear them, and I've asked today Messrs. Goldman, strike that, Messrs. Jerry Ullman, Bailey, Douglas are keying the offer of proof to the tapes and to the first transcript, of course, which is not on tape, that she did. And you'll have them by 5 o'clock today. In addition to that, you're aware that we have cleaned up all but 3 of the tapes for background noise, and I understand that by 10 o'clock tomorrow morning, the remaining 3 will be cleaned up, so you'll have those. So you'll have everything.
I'll have clean cassettes and a coherent transcript and an offer of proof that's keyed to the other.
The key to our verbatim transcript
Right.
by 5 o'clock, and the remaining 3 transcripts will be here by 10 o'clock tomorrow morning. Okay? And I apologize that the court had to go through anything that caused you any problems, because you got a flavor for it, but we want it to be so that you'll understand exactly where they're keyed directly in. We'll have it. And while we're about that, I'd like to find out, just for a matter of scheduling witnesses, how you plan to do that. Let's assume that you have the offer of proof and the transcripts and everything tonight. You also have our brief. We filed a brief regarding the admissibility of that this morning. What would be Your Honor's pleasure when will we get to the 402 hearing, given that schedule that I just laid out?
Well, see, that's the dilemma, because I had hoped to spend this weekend doing all of that, reviewing the tapes and comparing it, and then hearing argument and considering the prosecution's objections, because I didn't want to lose the jury time.
Sure.
But now it appears I'm going to have to use court time and my own after-hours time to do this.
All right, well, we'll be ready to try as much as we can to have witnesses to, fill in at least until you reach the point where you say, okay, let's do this.
All right, let me see counsel at sidebar without the court reporter, please. All right, thank you, counsel. Just want to make sure we have witnesses and our scheduling together. Ms. Clark.
Yes, Your Honor. With respect to the court's order filed today concerning the difficulty in locating those passages on the tapes, I should indicate to the court that with respect to the first entitled segment of the court's order, racial epithets, all of those portions are not on tape. That tape has been destroyed. All we have is Laura McKinney's transcript, quote unquote. It's not a verbatim transcript. I believe that's the same problem that you're going to find with the incidents of misconduct.
Well, why don't we
sanction.
save this argument? I
I'm
mean,
not going to argue. I'm just informing
Yeah.
the court that you will not find it in a verbatim transcript because
All right,
there's no tape.
That goes to the weight that I have to accord it to see whether or not it's trustworthy, reliable, and should be admitted.
And it does.
So-
And all I'm alerting the court is that if you're listening for this on the tape, you will not hear it.
All right.
Okay? None of this is on tape. With respect to the verbatim transcripts, we have prepared verbatim transcripts of all of the tapes that still exist, and we have agreed with the defense, I believe I agreed with Mr. Bailey last week, to furnish them a copy of our transcripts if they would give us a copy of theirs, and we agreed on that. So
And
what I'd
Mr.
like...
Cochran just reiterated that.
Yes, and if I could also request that whatever the defense is giving to the court, they furnish us a copy of that also.
All right. All right. Is this on the tapes issue?
No, this is on the discovery of Dr. Lee. You can take this
No,
up
I
now.
wanna-
You can take this up.
I'd like to finish the Furman tapes first. We have counsel for Ms. McKinney here who faxed to the court, and I think to counsel, a letter indicating their concern that transcripts of these tape recordings have leaked out. Gentlemen?
Thank you, Your Honor.
Mr. Schwartz, good morning.
Good morning. We're here to follow up on that letter that we wrote to you. We're concerned about these persisting violations of the court order. As the court may or may not be aware, last Friday morning, the Los Angeles Times printed an article that contained a verbatim portion of our client's protected intellectual property. And furthermore, the Reuters news organization transmitted over its wires across the country for everybody to see additional portions verbatim of our client's protected material.
Do you know the source of that? Is there any court document that may be the source of that?
We suspect that it would have originated from the defense's offer of proof, but we're not sure. But the giving of this information to the media at this point in time, especially since nothing has yet even been ruled admissible, is obviously in direct contradiction to this court's protective order. There have been 3 sets of our client's materials that have been disseminated during these proceedings. The originals went to the court, and we tendered a complete copy to the prosecution and a complete copy to the defense. Therefore, the people responsible for violating the court order are here today. And this court shares with our client a vested interest in the enforcement of this court order. Obviously, our client is interested in protecting her proprietary interest. But this court has to be concerned about the challenge to its authority that has occurred. If this challenge does not go unanswered, then perhaps the dominion of the court could be threatened, and the force and effect of future rulings of this court could be affected. And therefore, we're asking this court to request the attorneys on both sides to conduct their own investigations and try to find the source of these leaks. And if they're unsuccessful by perhaps close of business Wednesday or Thursday, we'd like to ask the court to conduct an evidentiary hearing wherein Mr. Regwan and I will be able to conduct a direct examination of the journalists who carried these stories throughout their organizations. And the news shield, the shield law, will not pose a problem, Your Honor, because the shield law will not protect officers of the court from violating a court order. If the shield law is raised, then it would unconstitutionally impinge on the independence of this judiciary. And so the shield law will be inapplicable. We've done the research. It'll be a very easy proceeding. We'll just bring in a couple of reporters and ask them point blank, where did you get this information from? And they'll be able to tell us.
All right, Mr. Schwartz, do you have a copy of the defense offer of proof that was filed late last week with regard to
No, I
Mr.
don't, Your
Brown?
Honor. I believe that was filed under seal.
All right, my staff compared that offer of proof with the quoted passage from the Los Angeles Times article. I did not read the article myself. However, they showed me highlighted portions, and they appear to come from the offer of proof. What I'll do, Mr. Schwartz, I will First of all, I'm going to direct counsel on both sides to file all documents with regards to this issue with the court under seal. Secondly, Mr. Schwartz, I'm going to direct that the clerk of the court give you a certified copy of the offer of proof so that you can compare it with the news leaks, and we'll see if we can at least pare down what the source, probable source is.
Okay.
All right, and then we'll take it from there.
Okay, thank you. Would you like me to reappear after I've had an opportunity to review the offer of proof?
Yes, you can notify the court of your position by mail,
Okay.
as we're going to be busy with other witnesses.
Okay.
All right, thank you.
Thank you
Mr.
very
Schwartz.
much, Your Honor.
All right. All right, anything else before we start with Mr. Regal?
Just one other thing, I just got a call from Mr. Douglas with regard to Dr. Reichardt. Apparently, he is scheduled for tomorrow morning. We cannot get him here today at all, anyway. Neither he nor his lawyer, so
Well, I think we're being optimistic if we think we're going to finish with Mr. Regal today.
hopefully that will not be a problem. That'll be tomorrow morning.
Okay.
And I'll be ready tomorrow.
All right.
Maybe we could, I want to bring up the Dr. Lee matter before, maybe after we break, or maybe just before we begin in the afternoon, because I think we have to set the discovery issue straight. We had some discussions about that this
All
morning.
right, you handed to the court, Mr. Scheck, a number of copies of your upcoming photo boards,
Yes.
most of which look very familiar to the court.
Yes, Your Honor, what has happened is that Dr. Lee, I guess over close to a month ago or so, filed a report in this case. We've turned over all the notes. We turned over to the prosecution Xerox copies of photographs taken at Albany and other photographs that they previously had from Dr. Lee, and photographs from these boards, many of which are their own photographs. I should note with respect to the Albany photographs is that they had a photographer and they had a witness on the scene for everything that was examined in Albany, so they have their own copies or an opportunity to look at those pictures. In any event, there is one, I believe one, maybe two, but one more board that is not reflected in those copies, which I know is arriving today, that is just a blow-up of other pictures that are contained within those boards, and other pictures that the prosecution has had available to it. Mr. Goldberg this morning, now the other thing is that there was mention of access to Dr. Lee and opportunities to talk to him and find out about his testimony, and that was broached by Mr. Hodgman and others at the crime scene. What you should know is that the prosecution, we have a difference, and I'll just chalk it up to misunderstanding, that I had communicated to Mr. Goldberg that when the prosecution talked with Dr. Lee, because he is always available to talk with the other side, that's his policy, it's the standing policy, that I wanted to be on the line so that we could have a record of it. He doesn't recall it, and that's fine. I don't want to dispute that. It's not an issue. They did, I believe, speak, they sent some questions to him. He was in Indonesia. They spoke with him about 2 or 3 weeks ago. Then
That man sure gets around, doesn't he?
he does. Then Mr. Hodgman and Mr. Goldberg, I believe, had a fairly extensive conversation with him either Saturday or Sunday. They can tell you best. I know from Dr. Lee that
All right, well, Mr.
Peter
Scheck,
DeForest, the
hold on,
rebuttal
hold on.
witness, went over those boards with
wait.
him on Sunday.
Wait, rather than tell me all this history, what's
Yeah.
the bottom line?
The bottom line is, they are saying to us this morning that unless, that they demand photo pictures of every photograph that we turned over in the Xerox materials. We only have one set of the Albany photographs. I offered to let them have any particular Albany photograph that they wanted. I have for them photographs of all pictures on the boards. Plus, they have a copy of the boards. Plus, Dr. DeForest spent 4 hours with Dr. Lee in his home yesterday going over the boards and going over his testimony, and Dr. DeForest is their expert and their rebuttal witness. More than this, we can't do. I can endeavor to try. Oh, and those are color Xeroxes, and they're terrific. So I don't know what else it is that they want by way of discovery. I guess, I'm unfamiliar with rules in this jurisdiction extensively, I guess, but the only other thing they could possibly want is for me to open up my files and show them the entire work product. This is unprecedented in my experience as a criminal defense lawyer. They have had an opportunity to talk with this man, to see every picture, to look at everything he's going to say prior to his testimony, go over it with a fine-tooth comb.
So all
I
I
don't know
need
what
to
else
do
to
is
tell you.
is ask Mr. Goldberg, what more do you want?
I don't know what else, yeah, what more do
All right.
they want?
All right.
Well, I want more, Your Honor, and I would have liked it much, much earlier. And I'm not prepared to give an in-depth argument on this issue right now because I don't have any notes as to dates and when I receive things. The generality is that the defense has dumped an enormous amount of documentation that is relevant to Henry Lee within the last few weeks relating to a number of different examinations of different items of evidence. And basically his testimony is going to cover the gamut of almost everything that came from the crime scene. So I would like to make at some point a much more extensive argument. Obviously it will have to be in the very near future about discovery sanctions because it has impaired our capacity to be ready. And I'm simply not prepared now to tell you, well, this report came from a examination in February and we didn't receive it until just 2 weeks ago. I just can't do that at this point, but I will be able to.
When?
I'll try to get that together as soon as I'm out of court on Mr. Regal. You know, I worked all day on Saturday and Sunday on Henry Lee and trying to prepare to the best of my ability with a great quantity of material. Now, the photographs that are being referred to, counsel has told, come from a variety of different examinations. Some of them were from the Albany trip. Some of them are from the LAPD
All right. Well, Mr.
examinations.
Goldberg, forgive me for interrupting you, but if you're not prepared to address the issue at this point, why don't we start with the jury with Mr. Regal? At least give them something to do today. You
Well-
and your other staff that are assisting you can put together your arguments concerning Dr. Lee, and we'll take it up at that time. But since
May I just add one thing, Your Honor? And the only reason why it might be helpful to address this now is on this very limited issue of the photographs, setting everything else aside. I've asked counsel for the actual photographs, and he said that the color Xeroxes are sufficient. That might be helpful to resolve now because it will probably take them some time to provide those to me if the court feels that the people are entitled to them. So the court might want to decide that now so that they can get those photographs to me as quickly as possible. Now, the reason why we believe we're entitled to the actual photographs as opposed to Xerox copies, color Xerox copies, is that in this case, as the court knows, we have put photographs up on the Elmo, and very frequently the defense will point out to some little speck somewhere, or the absence of some speck somewhere, or staple holes in the case of that exhibit, and hinge a massive theory of the case around the existence or non-existence of that speck. These photographs are purportedly examination quality photographs of things like impressions, of things like hair and trace material in soil and the like.
How many photographs are we talking about?
Well, there are approximately, and counsel could give you a more accurate estimate than I could, approximately, I'd say 50 pages of discovery containing photographs, and each page contains 2 or 3 photos. And Mr. Scheck perhaps has quantified
I
them.
can just get to the point, maybe we can solve this. Every photograph that we intend to introduce into evidence and that's on those boards, they can have. Just so you know, the dispute is that we gave them more. We gave them photographs from Albany, and I thank him for pronouncing Albany as Albany. We gave them that. So now what he's saying is, I want photocopies, not Xerox copies, of all these other things that you're not going to introduce that you gave to us, which you didn't have to give in the first place. Now, I only have one set of those at the present time in terms of photographs, and I gave him Xerox copies of it. And I've said to him,
These are color Xerox copies.
these are color Xerox copies. I've said to, and they're terrific. And I said to him, if there's any particular one of these photographs that we don't intend to introduce into evidence, he's going to get all the ones we intend to introduce, which I submit is our only legal obligation here. If you want another one of those and you need to see it, I'll give you that print. So I don't know what this is all
Seems like a
about.
non-dispute then. All right,
Well-
settle it over the lunch hour. Give him whatever photographs he wants that you're not going to use.
Well, I'd like all of the ones that, I'd like all of them.
Now, you're being unreasonable. They've given you color photographs. They can exhibit to you the originals. He's indicated he'll give anyone that they're not going to use. Settle it between yourselves at lunch. You guys are wasting my time here. All right, let's have the jury. Are they upstairs? All right, bring them down. Record in this Simpson matter, all parties are again present. Jury is not present. Deputy McNair, let's have the jurors, please. All right, and let the record reflect that we've now been rejoined by all the members of our jury panel. Good morning, ladies and gentlemen. My apologies to you for the late start this morning. Had a number of issues that we needed to determine out of your presence. I also wanted to give you fair warning. There's one major issue that I need to resolve with the lawyers that is coming up. My guess is that it will take me about 20 hours to examine the issues and the evidence that's being presented to me. And I anticipate using my evening hours to try to do most of that, but it may also include some court time. And I just wanted to give you a warning that there may be substantial dark time coming up this week, just so you know. All right, the defense may call the next witness.
The defense calls Larry Regal.
All right, Mr. Regal. Mrs. Robertson.
Raise your right hand, please. You do solemnly swear that the testimony you may give in cause not to before this court should be the truth and whole truth and nothing but the truth, so help you God? I do. Please have a seat in the witness stand and state your first and last names for the record.
My name is John Larry Regal. It's John, Larry, Larry, Regal, Ragle.
Mr. Blazer.
Ladies and gentlemen, good morning. Mr. Regal, you're here to testify as an expert in crime scene processing techniques, are you not?
That's correct.
Now, could you give us a brief description of your undergraduate training, educational background?
I attended the University of California at Berkeley, and I received a Bachelor's of Science degree in criminalistics, which is now called forensic science at Berkeley, in 1959.
And do you have any specific training as a police officer?
Yes.
And what does that training consist of?
I'm a graduate of the California Peace Officers Association Academy.
And what year did you graduate from the academy?
1957.
Now, could you describe your employment between 1956 and 1960?
In 1956, I became a member of the Berkeley Police Department. I was a patrolman and an investigator until 1960.
And in 1960, where did you go?
1960, I became an employee of the Orange County Sheriff's Department here in California.
And in your capacity with the Orange County Sheriff's Department now that was from 1960 to what year?
1989.
And from 1960 to 1976, did you have a particular area that you worked in?
Yes.
And what was that?
My assignment was as a general criminalist.
And what was the nature of your responsibilities as a general criminalist?
As a generalist, I investigated all types of crimes, either at the crime scene or analyzing evidence in court and testifying to my findings in court.
During that period of time, did you conduct any investigations into homicides?
Yes.
Any investigations into double homicides?
Yes.
Was your primary responsibility investigating crime scenes themselves?
No.
What was your primary responsibility?
My primary responsibility was analyzing evidence.
That would be after evidence was collected at a crime scene, it would be your job to analyze it.
Yes.
Now, from 1976 to 1989, what was your position?
In 1976, I was promoted to, at that time, what was called a chief criminalist, and that was the manager of the crime laboratory, the toxicology laboratory.
Is that basically the person that's in charge of the whole crime lab?
Yes.
And you held that position until what date? What year?
Technically, in 1977, that position was changed, and the title became the Director of Forensic Sciences. So actually, I held the position of Chief Criminalist for 1 year. In 1977, the crime laboratory and the toxicology laboratory was combined with the Identification Bureau, which is all the crime scene investigators, and the coroner's office.
Would it be fair to say that your job was similar to Michelle Kessler's job in Los Angeles County? That your job in Orange County was similar?
You could say that. There was additional responsibilities.
Are there additional responsibilities that you had?
Yes.
And what did those consist of?
The coroner's office, for one, was an organization that investigates all types of deaths, not just deaths that are suspected crimes. The Crime Scene Identification Bureau and the Cal ID Bureau, which is the automated fingerprint system, and in the coroner's toxicology section. And those are not part of the Los Angeles Police Department SID.
In your capacity as the director of the Orange County Crime Lab, approximately how many people did you supervise at any given time?
Well, the lab grew during that period of time, and by the time I retired, there were between 100 and 110 employees.
And how many of those people were criminalists or toxicologists?
Approximately 60.
What types of cases would you respond to, or your people would respond to, from the Orange County Crime Lab?
In the criminalistic section, which would be similar to Los Angeles Police Department's SID, the types of crime scenes that we responded to would be question deaths, drug laboratories, post-bomb detonation scenes, arsons.
Now, did you go to crime scenes that were being processed just by the Orange County Sheriff's Department or other police agencies in Orange County?
Both.
Now, I think you indicated that the coroner's office was also under your direction at some point in time. What period of time was that?
From 1977 until 1986 or 85, right in that time, or 9 years.
Now, at the time that you retired from the Orange County Crime Lab, is it accurate to say that that was considered to be one of the best crime labs in the country?
It was, and I believe it still is.
Can you give me a rough estimate of the total number of crime scenes well, let me ask you this about homicides. How many homicides per year are there in Orange County?
The average would be around 150. It has been, starting when I first was an employee of the department, somewhere around 50 to 60, and by the end of my career, homicides were somewhere in the number of 200.
And approximately how many of those homicides would your office be involved in processing the crime scene?
Approximately half.
Now, the other half would be processed by who?
By some of the cities two cities had crime laboratories, small crime laboratories, or by their field evidence technicians.
For all of the homicides handled by the Orange County Sheriff's Department, would it be your responsibility or the people working for you to process those scenes?
Yes.
Since your retirement in 1989, what have you been doing?
Primarily, I've been acting as a consultant in the management areas of forensic science.
And do you have a company that has a name?
Yes.
What is that?
The Center of Forensic Sciences.
Now, when you say consulting, what sorts of consulting do you do?
It really falls into a couple of different categories. One would be the needs assessment. That is, what type of response should a crime laboratory be able to offer to the criminal justice system, to all levels of the criminal justice system. And then also in the area of laboratory design, space allocations relative to staffing and caseload.
Have you been involved over your career with designing crime labs or redesigning crime labs?
Both.
Can you give us just a couple of examples?
Well, the laboratory in Orange County is the one I'm most familiar with, because that laboratory was redesigned on several occasions unsuccessfully. That is, we made a design, but nothing ever happened with that design. But ultimately, at the conclusion of my employment, the county agreed to build a new forensic science facility.
And have you worked for other counties as a consultant?
I also want to say that I was also involved in the design of what is called the Forensic Center in Orange County, which is the morgue. And I have worked for other counties.
What other counties have you worked for?
As a consultant, after I retired, San Diego County and Contra Costa County. Before I retired, Ventura County, Santa Clara County, and San Diego County.
And does that involve law enforcement officials from those counties contacting you and retaining you to help them with their crime labs?
Yes.
Now, do you have any teaching experience?
Yes.
Are you currently teaching classes?
Yes, I am.
And what's the subject matter of the classes that you teach now?
The class that I'm teaching for the University of California at Los Angeles is a class called Crime Scene Investigation, or Field Evidence Technician class.
And just generally, what does that encompass?
It encompasses the process of processing a crime scene, the entire scope of processing a crime scene.
And how long have you been teaching either that course or other courses that have the same topic?
That course started in 1968 and is essentially unchanged in its nature, although there have been technical improvements in crime scene processing.
Now, how long does that class take, the way it is now?
The class is a two-week class involving the students being at the classroom 8 hours a day.
And what's the students that take your class, what are they primarily made up of?
Right now it's about a 50-50 split. That is, about half of the students are police officers, sworn police officers, and the other half are civilian employees of law enforcement agencies. Occasionally there's a student who is seeking employment in some sort of law enforcement agency that takes a class.
Now, did you want to add something about the length of time that your classes take?
Well, I didn't want to imply that I was involved in the class for the entire 2 weeks. My part of the class is 2 days of each session.
Now, do you have any FBI agents in your class?
There have been, yes.
Did you, has the FBI been sending people to your class partly as a result of your involvement in this case?
Well, that calls for speculation.
Well, during your work on this case for the defense, have you had contact with FBI agents?
Yes.
And since that,
Not relevant, Your Honor.
Sustained.
approximately how many people have attended your class since it started in 1968?
In the neighborhood of 4,000.
Have any people from the Los Angeles County Sheriff's Department attended your classes?
Yes.
Do you know how many?
I don't know how many. It would be the total number of the people assigned to their crime scene investigation bureau.
To your knowledge, has anyone from the LA Police Department, SID, ever come to any of your classes?
No.
Have you been a lecturer at any law school?
Yes.
And where is that?
In Orange County.
Have you ever testified as an expert in court?
Yes, I have.
Approximately how many times?
If you include every type of case, close to 1,000 times.
And is that primarily when you were working with the Orange County Crime Lab?
Exclusively.
During that period of time, were you ever...
I was going to say, I've testified a few times in Berkeley, but on a rare occasion.
But most of your experience testifying has been in your capacity with the Orange County Crime Lab.
That's correct.
Have you ever been called as a witness by the defense?
Yes.
Approximately how many times? Wait, let me limit that to when you were with the Orange County Crime Lab.
5 or 6 times.
And was that as a result of the defense retaining you or for some other reason?
That was some other reason.
And what would that be?
The results of my examination in the laboratory favored their client.
Could you describe the professional organizations that you belong to?
I'm a member and a past president of the California Association of Criminalists, CAC. I'm a member emeritus of the California Society of Crime Laboratory Directors. I'm a fellow of the American Academy of Forensic Sciences, and I'm a member emeritus of the American Society of Crime Laboratory Directors.
Have you received any appointments during your career in your area of expertise?
Yes.
What sorts of appointments?
I've been a member of the California Department of Justice DNA Advisory Committee that was part of the Attorney General's study on DNA. I was a member of the California Department of Justice, what they call CCI, which is the California Criminalistics Institute, which is a training organization, and that role included recommending types of classes and training that would benefit crime laboratory employees. I was a member of the California Department of Justice's CalID user committee. The user committee was a group of people like myself who were managers of laboratories that were in the process of installing the California computerized fingerprint identification system called CalID. And I've been a member of the State of California Epidemiology Study Group, and I was a member and the chairperson of the FBI Committee on what was called Forensic Science Operations and Procedures Committee, which was a committee that recommended to the FBI training section the types of research and the types of classes that would be most beneficial to law enforcement agencies.
Who appointed you to that FBI committee?
The president of the American Society of Crime Laboratory Directors. or the board, I'm not sure which. I think as a group, they make those appointments.
Do you hold any licenses or certificates in your area of expertise?
Technically, no longer.
Have you held licenses?
Yes.
And why don't you tell us what those are?
At one time, I was licensed as a supervisor of the forensic alcohol analysis, a state license. I also was certified as a generalist in the field of criminalistics by the California Association of Criminalists, and that particular certification is now defunct. It expired after 5 years. Actually, it didn't really expire after 5 years. It was changed to a different organization, and I have to take a new examination this year if I'm going to be certified again.
Now, is that the organization that provides accreditation to crime labs as well? Or is that the American Association?
It's not the same. No, it's a different board.
Do you know whether the California Association of Criminalists still certifies criminalists?
No, they don't.
And who does that now?
The American Board of Criminalistics.
Have you published any articles or made any presentations concerning your field of expertise?
Yes.
Could you describe briefly what some of those publications and presentations are?
Early on, I did some presentations on toxicology tests that I had developed in the laboratory on determining amphetamines and amphetamine-type compounds in body fluids. I published not an article, but a chapter on forensic science in a textbook that was generally called Principles of Investigation, or something like that. I don't remember the exact title. I made presentations at the American Academy of Forensic Sciences on 2 particular cases that I felt were something that the scientific community should be aware of.
And one of those involved the falsification of evidence?
Yes, it did.
And just tell us briefly what that was about.
Sustain.
Do you currently have a book that's in the process of being published?
Yes, I do.
And what's the name of that book?
Crime Scenes.
Is that a textbook or is that a general interest book?
It's a general interest book.
And was that book completed prior to the time that you were hired to work on this case?
Yes, it was.
But it hasn't yet been published, has it?
It's been published. It'll be released this year sometime.
During your tenure with the Orange County Crime Lab, did you ever have any experiences with outbreaks of contamination?
Yes.
And what was the response to the outbreak of contamination that you had experience with?
Well, there's no foundation for
Sustained.
qualifications of these.
It's also vague.
Prior to being retained by the defense in the Simpson case, had you been hired by the defense in any other criminal cases?
Yes.
And approximately how many?
2.
Were those large cases like this one, or were they relatively minor cases?
Well, they were, I don't know if you could call them relatively minor. My aspect in the case was relatively minor.
Have there been other instances where you've been asked to work on the defense side of criminal cases where you've refused?
Yes.
Does that happen fairly frequently?
No.
Now, you've received compensation for your services during this case, have you not?
Yes, I have.
And when did you first become involved with the Simpson case?
In the latter part of June of 1994,
And that was at whose behest?
Dr. Henry Lee asked if I could be of some assistance.
And have you been involved working with the defense on a somewhat continuous basis since that time?
Yes.
Your Honor, may we approach on a matter?
With the court reporter. All right, thank you, counsel. Proceed.
Mr. Regal, you indicated that you first became involved approximately June 26th of last year.
Yes.
And have you been regularly involved in the case on a semi-continuous basis since that time?
Yes.
And has that involved numerous meetings and sessions where we've discussed crime scene processing issues?
Yes, it has.
And have you watched much of the testimony in this case on television about crime scene processing from the detectives as well as the forensic people as well as the coroner?
Yes, I have.
Can you tell us approximately how much you've been paid so far in this case?
To date, approximately $35,000.
And what is your regular billing rate?
My regular billing rate would be $200. That's not what I've been charging in this case.
And what have you been charging in this case?
For attending the meetings, half of that, $100 an hour. For monitoring testimony on TV, $50 an hour.
And is the amount that you've been paid so far, does that cover everything you've done, or do you have a certain amount that you'll be billing after this?
The last bill I submitted included June, and I haven't been paid for that, or possibly, yeah, June. I didn't do anything in July, and now this month.
Mr. Regal, given your training and experience in the area of crime scene processing, do you have an understanding of the minimum standard of practice which should be used to process crime scenes?
Yes, I do.
Now, did I ask you to try and break down the processing of a crime scene into some categories for me?
Yes, you did.
Your Honor, could we have two slides marked next in order? 1326, A and B.
Fine, A and B. Do you have any more you need to show, Mr. With the court clerk, please.
We have 1326A, please. Mr. Agel, can you see the monitor there to your right?
Yes, I can.
And the categories on the chart, recognition of evidence, protection of evidence, documentation, collection, and preservation, are those the categories that you broke down the various steps of crime scene processing into?
Yes.
Could you tell us briefly what, we want to go through each of those categories, what you mean by the term recognition of evidence?
The recognition of evidence in this context means that the individual, either the police officer or the field evidence technician or the criminalist, has either an innate ability, an intuition, or special training in what types of evidence would be important at a particular crime scene. Since every crime scene, the evidence varies, they have to be aware of the consequences and the significance of particular types of evidence, and then set forth some method of capturing that.
And the term protection of evidence, what do you mean by that?
The protection of evidence in relation to the first category, the recognition, both of those are sort of ongoing processes throughout any crime scene investigation. The protection specifically is taking some measure that will assure that that evidence isn't changed once the investigative team arrives at the scene. So that the concept here is that, you know, if they could, they would freeze the entire evidence and they would pick it up and take it to some safe haven. So they set up barriers, they maintain a log of the people who come in and out of the crime scene, and most importantly, they minimize the type and the number of people that come in and out of the crime scene.
Now, the term documentation, how are you using that term?
That is an all-encompassing term that would include the specifics of the location of each item that is believed to be evidence at the time, what appears to be relevant to the investigation at the time. And it includes photography, at least 3 different types of photographs, a general photograph of the scene where this object might be seen and off in the distance, a close-up photograph of it, what I would call an orientation photograph, and then a very close-up photograph where there is some documentation as to the size and the nature of that particular item, what it might be. Then those items that are considered relevant are measured very precisely relative to some fixed objects at the crime scene, so that if it's necessary, that whole crime scene could be reconstructed, and people who weren't at the crime scene to begin with could recognize and understand where each item of evidence was. And then finally, the evidence's documentation carries on into some of these other phases, which is the collection of the evidence.
All right, now, collection, how are you using that term?
The collection would be the physical picking up of the object in such a way that its value as evidence is maintained. And it may be packaged, it may be something that has to be carried to maintain its integrity, its originality. It might have to be packaged in something to just carry it in your hands, like a pizza box or some type of open container like that. A loaded weapon, as an example.
And preservation of the crime scene, what does that refer to, or preservation of the evidence?
The preservation of the evidence, again, is an ongoing subject. It pertains to maintaining that evidence in as close to its original condition as possible. And that begins, obviously, with the protection of the evidence so nothing happens to it, and then ultimately in the way it is packaged, so it's packaged in something that accommodates the object, that doesn't add to any destruction of the evidence, that doesn't change the nature of the evidence, and then the preservation goes on until then how that evidence is stored. Some objects have to be stored frozen, some refrigerated, some dry.
When you talk about protection of the evidence and keeping it in its original condition, does that include also the any trace evidence that might be on pieces of evidence in terms of maintaining that it's in the same place when it was found as when it's collected?
Yes, it does.
Why is it important that these steps be done properly?
The main reason is that if evidence is in any way degraded or altered, its potential, what I call individuality, its uniqueness, can change, can be lost. Obviously, if evidence is not go back to step one in this outline. If evidence is not recognized or properly documented or collected, it can leave a lot of unanswered questions. I mean, many crime scenes contain a lot of information that could answer questions. And so if these things are not done, evidence of a person's involvement might be overlooked, or evidence of a person's non-involvement might be overlooked.
You used an analogy with me when we were discussing this of a dictionary. Could you explain that to the jurors, please?
And sort of a simplistic statement that I said is that every crime scene is like a book or a dictionary. I mean, if you know where to open up the pages and look up the information, you can answer many questions. And most crime scenes, not all, but most crime scenes are loaded with information. If the crime scene team is trained and interested in finding this information.
And what are the consequences that can result when this is not done properly?
Well, you miss the information. What I mentioned a moment ago, particularly,
No
is
question.
Sustained. Next question.
Well, you talked about evidence losing its individuality. What did you mean by that?
a good example of that would be like if the fingerprint was discovered at a crime scene that had all the detail that could be established to show ownership of that fingerprint, and it is not collected properly or ignored until somebody smudges it, and now all you can say is it's a fingerprint. It might have fingerprint characteristics, but the fine detail is now missing, and the fine detail is what is necessary, for identification.
Now, given the resources available to the Los Angeles Police Department, do you have an opinion as to whether their processing of the crime scenes in this case, and by crime scenes I'm talking about Rockingham and Bundy, fell above or below minimum standards of practice?
Not relevant, Your Honor, no foundation.
Foundation sustained.
Are you familiar with the resources available to the Los Angeles Police Department?
Yes,
Are you familiar with their crime lab?
somewhat.
And have you followed all the testimony about the manner in which the crime scenes were processed in this case?
Yes, I have.
And you're familiar with their crime scene truck and the equipment that they've testified to that they have available to them?
Yes.
Now, do you have an opinion, with that understanding in mind, do you have an opinion as to whether their processing of the crime scenes in this case fell above or below a minimum standard of practice?
Still no foundation, not relevant, calls for opinion or speculation.
You can't.
You can answer.
Yes, I have an opinion
And what is that opinion?
that it fell below a minimum standard.
Now, what is your basis for that opinion?
The basis of the opinion, in my opinion, that it fell below a minimum standard.
I'm going to check, calls for a narrative.
Or you can answer the question.
The outcome of the evidence, the things that occurred to the evidence that caused it to lose some of its individuality, some of the items that were contaminated at the evidence in the sense, for instance, there was something placed over a body at that crime scene, which was a mistake in the sense of the choice of whatever it was. Not a mistake necessarily to cover a body if it's in public view and there's some question of just a humanistic aspect of covering up the remains of somebody.
Well, let's talk about that specifically. You're familiar with the testimony that a blanket was removed from inside Nicole Brown Simpson's condominium and was placed over her body.
Yes, I am.
And when you indicate that that was a mistake, could you tell us which aspect of that is a mistake?
Well, there are really two aspects. The first is the fact that they picked something from the crime scene.
Again, this is not relevant.
Oh.
This is our previous argument this morning.
Noted. Thank you. Overruled.
They selected something from the crime scene and used that. And it leaves a lot of unanswered questions as to that, the condition of whatever it was they picked, I believe a blanket. But the biggest problem, from my perspective, is that they then did not collect that blanket and retain it for whatever evidential value it might have had. Because it was in contact with one of the bodies, there are all kinds of possibilities of transfers from, if not from the blanket to the body, from the body to the blanket. And that could have been helpful, and it's just something that should have been done.
Now, you've indicated that there may be humanistic reasons to cover a body at a crime scene. Are there any legitimate forensic or investigative reasons for covering a body at a crime scene?
Only if weather conditions would cause that need.
Now, suppose hypothetically that the blanket that was used had recently been laundered. Does that make any difference in your view?
No.
Why not?
Well, you still don't, unless you have the blanket to look at, you still don't know what might have been on it or not on it. And and more importantly, you don't know what was transferred to it after it was used.
Now, you're familiar with the testimony that there were some blood droplets on the back of Nicole Brown Simpson.
Yes.
In your opinion, is the manner in which that was handled proper?
No.
Please explain your answer.
Well, that obviously is very important evidence, and it was not collected at the crime scene, and there was some explanation as to why it was not collected at the crime scene, which I find unacceptable.
What's your understanding of that explanation?
Well, this is calls for hearsay.
Sustain. Rephrase the question.
Well, is your opinion based on your understanding of what the reason was that that was not collected?
Can I answer that in a narrative form?
Nope.
No.
What's the basis of your understanding? Was
What's-
it the testimony that you heard?
Yes.
All right. Proceed.
And what's your understanding of that testimony?
That it was not the job of the criminalist, it was the job of the coroners to collect that sample.
And when you say that's not acceptable, what do you mean by that?
Well, unless the coroner's experts are at the scene, by putting the body in a body bag, all that evidence is destroyed, or
Is
at
it
least contaminated.
Is it important in your view that the coroner's office, the scientific investigation division people, and the detectives work closely together?
Is it my observation that they work closely together?
No, is it your opinion that they should?
That they should, yes.
And from what point in the investigation should that occur?
From the very beginning.
Now, let me ask you some questions about timing of when various people were called to this crime scene occurred. Are you familiar with the time frame in which the criminalists were called, the coroners were called?
Yes, I am.
Now, what's your understanding of when the bodies were found?
12:15 a.m.
And when was the first call to the criminalists, approximately?
My understanding is it's 5:30.
And what's your understanding as to when criminalists arrived at the Bundy scene to begin processing that scene, approximately?
7 a.m.
Is there any, in your opinion, any legitimate investigative or forensic reason to be served by not calling criminalists for approximately 10 hours to the primary crime scene? back up one question. What's your understanding of when the criminalists arrived at the Bundy scene to begin processing that?
At the Bundy scene?
Yes.
I believe 10:15, or in that time frame, 10:15, I believe.
Now, in your opinion, is there any legitimate investigative or forensic reason or purpose to be served by not having the criminalists at the primary crime scene for 10 hours?
No.
And what's your understanding as to when the criminalists began processing Rockingham?
Began processing Rockingham?
Yes, or arrived at
at
Rockingham.
7 a.m.
Now, we've had testimony that the detectives, Lang, Van Adder, Phillips, and Furman, left the Bundy crime scene at approximately 5 o'clock in the morning to make a death notification to Mr. Simpson. In your opinion, is that an appropriate procedure to take?
No.
Foundation for
Sustained.
In your view, is there any legitimate investigative or forensic purpose for the investigating detectives to leave the primary crime scene for a period of time to make a death notification?
Sustained.
How many people does it generally take to make a death notification?
argumentative, same objection.
Sustained. Foundational problem with all that line of questioning.
Well, did you watch the testimony of the detectives in this case as to when they went to Rockingham and for what purpose?
Yes.
Do you have an opinion on whether it's an appropriate procedure to use in investigating a crime scene to have all the detectives leave the primary crime scene to go to what might be a secondary scene?
Same objections.
Sustained.
Mr. Agel, do you have any experience on the procedures that are used to make death notifications in homicide cases?
Yes, I do.
And what does that experience consist of?
As the director and in charge of the day-to-day operations of the Orange County Coroner's Division, I'm aware of how notifications are made.
And do you have an opinion on the appropriateness of having 4 detectives leave the primary crime scene to go to a secondary scene to make a death notification?
Not relevant, no foundation.
Sustained. Let's abandon this line of questioning on the foundation.
I'm sorry?
Foundation. It's not there.
In your opinion, what is the importance of having criminalists respond to a crime scene as soon as possible?
The reason that you would want a criminal to come to a crime scene as soon as possible is the nature of some evidence is in question, is perishable. And you never know what weather conditions may be. So the sooner they arrive, the less chance of any degradation or loss of evidence.
Now, when you say some evidence is perishable, what do you mean by that?
Well, biological materials, for example, blood, in a hostile environment such as a crime scene, the ground is not in its normal environment, can go bad.
What is the importance of having the coroner called to a crime scene as soon as possible?
My experience with having the coroner come to the crime scene as soon as possible is that they are trained in establishing or estimating the time of death.
Is it important that all of those agencies begin working together at the very earliest moment?
In my opinion, it is, yes.
Are you aware of any legitimate investigative or forensic reason to not begin processing the Bundy crime scene until 10 hours after the bodies were discovered? Approximately.
No foundation, Your Honor.
Overruled on that basis. Go ahead, answer those.
There's no reason that I know of.
Do you have an opinion on the appropriateness of only, with the complicated crime scenes present in this case, of only having one team of criminalists working all crime scenes?
Do I have an opinion?
Yes.
I would say it would be inappropriate.
What would be the appropriate procedure?
The appropriate procedure would have been to, or would be to call at least a second team of criminalists.
Are you familiar with the equipment that Andrea Mazzola and Dennis Fung had available to them in their crime scene truck for examining for latent shoe print evidence at the crime scene?
Vague.
Sustained.
Are you aware of whether or not there was ever any search done in the dirt area of the Bundy crime scene for latent shoe prints?
Speculation, no foundation of personal knowledge.
Overruled.
In the reports that I was given, I found no evidence that that was done.
And do you know whether or not the Los Angeles Police Department in their crime scene trucks has equipment to conduct such an analysis?
Not relevant, calls for speculation, no foundation.
Overruled.
Well, actually, there isn't any special equipment needed to look for shoe impressions in soil other than a flashlight at night.
Is there, in your opinion, is there any legitimate investigative or forensic reason not to do that at a crime scene such as Bundy?
Your Honor, this makes improper. It's contrary to the evidence.
Overruled.
Remember the question?
Yes.
Is there any reason not to look for footprints?
No.
Next question.
Mr. Regal, what techniques are available to look for shoe prints in dirt at night? What's the role of oblique lighting in examining shoe prints?
Not relevant.
Overruled.
Oblique lighting is light at an angle and light at a sharp angle, so any indentations in whatever it is, whether it's soil or indented writing or anything like that on a piece of paper, the shadowing accentuates fine detail, so it allows a person to to see something that could be very subtle or something quite obvious.
Now, I have two photographs that I think are actually already in one form. These are just blow-ups that I'd like to have marked.
Mrs. Robinson, this would be 1326 and 1327? Excuse me, 1327, 1328. All right. First one will be 1327, Mr. Blazer. No. We'll never get out of here.
Incidentally, Mr. Regal, are there any advantages to looking for shoe prints in dirt at night versus in the day?
Yes.
What are those advantages?
The oblique light, which would be holding a flashlight at a very sharp angle in the dark, allows you to accentuate any fine detail much greater than if you had ordinary daylight radiating down from various angles and reflecting off other surfaces.
Is that also true for shoe impressions or residues on hard surfaces as well as dirt?
Not necessarily with oblique lighting, but with other types of lighting it might be.
Let me show you what's been marked as Defense 1327. Mr. Harris, I think we can do this up here.
All right, 165, can you see that? Yes, sir. Thank you.
I'd like to put up 1328 at the same time.
All right. Mr. Blazer.
Drago, can you see the two photographs we've put up?
Not very well.
Okay, you can step down and take a look at them if you like. You've seen those photographs before, have you not?
Yes, I have.
And what is 1327 a picture of?
All right, Mr. Ray, would you address the jury when you're giving your answers, please?
I don't know which one is 13.
The one on the left.
Okay. This is a photograph of the glove and part of the pavement that was a sidewalk at Bundy. And this is apparently the hat and someone pointing their finger at this particular item.
Now, we've had testimony indicating that's Detective Furman pointing at a glove. Is there, in your opinion, any legitimate investigative reason for having a picture with a detective pointing at a piece of evidence?
No.
What is the standard procedure with respect to photographing items of evidence with respect to having people in the photographs?
It's generally avoided.
And why is that?
Partly tradition and partly it obliterates other parts of this photograph.
Roll.
Does having another person walking around the crime scene cause any potential problems as well?
Certainly unnecessary.
Now, 1328 is a picture, a later picture of the glove with an evidence tag on it. You've seen that one before?
Yes, I have.
Objection at the state's testimony. There's no tag on it.
Or sustain, rephrase the question.
With a number card that says 102.
next to it.
next to it.
All right, that's a photographer's ID number, correct?
Yes.
All right.
Now, did I ask you to compare those two pictures to determine whether there had been any alteration of that particular area of the crime scene between the first picture and the second picture?
Your Honor, this is cumulative. We've gone into this at length.
We have previously. I'm not saying I'm going to sustain the objection, but we have visited this issue before.
I'm going to be very brief.
All right, proceed.
Mr. Regal, is it important in the process of protecting a crime scene that evidence not be altered or moved or picked up or replaced prior to the time of its collection and processing?
Yes, it is.
Why is that important?
For the reasons I expressed before, the integrity of the evidence is then in question. The potential of adding or subtracting something from the evidence that can occur.
You could resume your chair, please. I'm wondering if we might display these to the jurors. I'm not sure they can all see them.
1386, can you see those? If you want, Mr. Blazer, you can bring them up and just display them briefly at the front of the center of the jury box. However, these photographs have been displayed before. So this is to allow the jurors to recollect and refresh their recollections as to these two items. All right, thank you, counsel. About the shift?
Yes.
All right, ladies and gentlemen, we're going to take our break for the lunch hour at this time. Mr. Regal, so you can step down. You're ordered to come back at 1 o'clock. We'll stand at recess until 1 o'clock. Please remember all my admonitions to you. Don't discuss the case amongst yourselves, form any opinions about the case, conduct any deliberations till the matter has been submitted to you, or allow anybody to communicate with you with regard to the case. We'll stand in recess until 1 o'clock. And Mr. Goldberg, Mr. Scheck, confer with each other on those other two issues. All right, thank you. Back on the record in the Simpson matter, all parties are again present. Counsel, anything we need to discuss before we invite the jurors to join us?
Yes, Your Honor, very briefly.
Always scare me when you say very briefly.
This will be brief. I would ask the court for a little bit of latitude with Mr. Regal. I know that some of these materials have been covered before. However, it's all been through our cross-examination of prosecution witnesses. Mr. Regal is the first person we put on as our witness on crime scene and processing.
I understand that.
The other point is, I intend to ask him questions regarding the movement of evidence, the envelope and the glove prior to collection. And I wasn't here on Thursday or Friday, but I understand that there was a bench conference where the court stated that it was the court's impression that there had been testimony explaining how those items got moved. We do not recall any such testimony, and I want to make sure that we're clear on what is in the record before I pursue that avenue. We have not found any reference anywhere to any witness explaining how those items got moved. That's our current understanding.
Well, that's not my recollection. My recollection is that we've heard testimony from the investigating officers, Lang and Van Adder, that there were certain items in place, that bodies were moved, and then that they were replaced and photo cards placed.
We don't recall any such testimony.
Yep.
They've acknowledged, obviously, from the photographs that the items
Right.
were moved in some fashion, but I don't recall any testimony where they said, yeah, I did it, or he did it, and this was just to put things
No,
down.
I recollect an explanation for that, but that's not to say that you can't have your experts say that's not a good idea no matter how it happened,
Okay.
for obvious reasons. But I just might add that the jury, I think, can figure that out. You don't think so, Mr. Scheck? No, that's a rhetorical question. Let's have the jurors. I'm,
When we get time, we should have a discussion about what the record states and doesn't.
well, I have a pretty clear recollection that that's already occurred. All right, let's have the jurors, please. I don't know. I'll have to ask Mr. Blazier. He's the one seated. Mr. Regal, would you resume the witness stand, please? All right, good afternoon, Mr. Regal. Record to reflect, Larry Regal is on the witness stand undergoing direct examination by Mr. Blazier. Mr. Regal, sir, you reminded you were still under oath. Mr. Blazier, you may continue with your direct examination.
Thank you, Your Honor. Good afternoon, ladies and gentlemen. Mr. Regal, I wanted to ask you just a couple more questions about latent or faint shoe prints or other impressions that might be left at a crime scene. Did I understand your testimony before lunch to be that the nighttime is a much better time to locate such prints, if they exist, than the daytime?
Overruled.
If we're talking about a nighttime outdoor location, yes.
And what equipment is available if a latent or faint shoe print was visible or was identified that way? Are there procedures available to make a record of that and preserve those prints?
There are lifting devices that are available, static electrical dust lifting devices, and there's ordinary rubber lifting devices that are available.
And do those techniques allow you to preserve such prints so that they can be analyzed later or examined by any parties later?
Yes, they do.
Are you aware of whether or not the Los Angeles Police Department SID division has such equipment available to it?
It's listed in their procedurals handbook, their they call it their crime scene policies and procedural handbook, or field scene, something like that.
Motion to strike, non-responsive.
Sustain. Answer stricken. Jurors to disregard. Question was, do you know if they have the equipment, not what their manual says?
Do you know if they have such equipment?
No.
Is that equipment that's readily available to law enforcement agencies everywhere?
Yes.
Now, I'd like to show Mr. Regal Defense 1071.
Which page, counsel?
Well, I'm going to show him the manual initially.
Right.
Show you 1071. Does that appear to be the field manual that you were just referring to?
There's no foundation that he can authenticate that, Your Honor.
Overruled.
This is the document that I was referring to.
Is it important, in your view, for a crime lab to have a manual in place that sets forth procedures to be used by criminalists in processing crime scenes?
Yes.
And there's been testimony that that manual has never been actually adopted, that it's existed for several years and has never gotten past the first draft stage. In your opinion, is that acceptable procedure with respect to having your methods documented?
Not relevant, Your Honor.
Overruled. You can answer the question.
The question is it acceptable to not have these methods
Yes.
you adopted?
Not have any methods set forth in a manual that guides everybody on collecting evidence the same way.
I don't understand the question.
Okay. Have you reviewed that field manual, the portions of it that relate to evidence collection?
Not
Yeah.
relevant, Your Honor.
Overruled.
Yes, I have.
And do you have an opinion on whether certain parts of that manual state procedures, correct procedures that should be used in processing evidence?
Yes, they do.
one question about death notification. What is the standard practice with respect to death notifications in homicide cases?
Same objections previously made.
Sustained.
Do many of the suggestions or comments that you've made about inadequacies with the Los Angeles Police Department relate to the prevention or the detection of evidence tampering?
Misstates the testimony. You didn't talk about any inadequacies.
Sustained.
You recall when we talked about the 5 categories of processing a crime scene and what the general framework is, what your goals are in processing crime scenes?
Yes.
And how does that relate to prevention or detection of evidence tampering?
The step that I described as documentation, all of that, all the efforts within that particular step are intended to maintain the integrity of the evidence, the identity of the evidence, and to establish that only authorized individuals who either collected the evidence or in any way opened the evidence or worked with the evidence are recorded.
Are you familiar with tamper-resistant seals for evidence items?
Yes?
Now, have you followed the testimony with respect to the drawing of Mr. Simpson's reference blood and the procedure that was used to preserve that and transport it?
Yes, I am.
Now, let me show you People's Exhibit 163H. That is a sample envelope that corresponds to the envelope used to contain Mr. Simpson's reference sample. Is that what that appears to be to you?
Yes.
Now, the procedures set forth on that envelope indicate that it should be sealed once the evidence...
Sustained. Rephrase the question.
What is the proper procedure with respect to sealing evidence at the time that it is collected, in your view?
With this specific item or any item?
Well, let's take that item as an example.
Any time a sample is placed in a container like this and then transferred from one person to the other, the evidence should be sealed by the person who is the originator of the evidence,
And what's the reason for having it sealed at that early stage?
so that its identity and integrity is without any question.
In your opinion, is it acceptable to place a reference blood vial in that envelope and have it remain unsealed for several days?
Your Honor, it calls for speculation, no foundation.
You can answer the question.
In my opinion, that's not a good practice.
What is your opinion as to the proper technique that should be used in terms of marking evidence as it's collected?
Isn't that kind of vague because we have such a wide range of different types, some of which can't actually be marked itself?
All right, let's take as an example the swatches that were made from blood stains. And I'm going to ask you specifically about the procedure that should be used to identify those or mark them. In your opinion, what is the appropriate procedure to use once that item is collected?
Since swatches cannot be actually written on, they should be documented by counting them, by placing them in some sort of container where they will be dried, if they're not already dry. Ideally, they would be either photographed or sketched, and then they would be placed in a package and sealed. And in this case, since it's available sealed with some sort of tape such as this tape.
And again, what is the reason for that?
I don't think we need to ask questions again.
I'm sorry?
We don't need to ask questions again.
Does the LAPD field manual that is not actually in effect provide a procedure for fully documenting the collection of evidence?
Calls for hearsay.
Oh,
No authentication, no foundation.
oh,
I believe it does, yes.
Now, with respect to removing dried blood stain from various surfaces, do you have an opinion on the proper way that that should be done?
Yes?
And what is that opinion? I mean, how should that be done properly?
Well, the best way to remove a sample of blood from any dry surface that's not movable, the best way if it's on a movable surface is to move the surface directly to the laboratory by the process we've already discussed, the documentation, packaging, and preservation. But if it's on something that cannot be moved, the first attempt should be to at least evaluate whether or not some of it can be scraped off of the surface with a probe or with a scalpel blade or something like that, so that the blood is left in as close to the same condition it was at the crime scene. If that's not possible, or if only part of the sample can be removed that way, then the next step is to dampen something, either a swatch, that's the technique that's used in Los Angeles, or at least liked by the Los Angeles Police Department, or a cotton swab, similar to a Q-tip. And to dampen that and then to apply that to the remaining stain or whatever is left of the stain until all of that is transferred onto the cotton.
Now, there's been testimony in this case that wet blood swatches were stored in plastic bags. In your opinion, is that an acceptable technique to use to preserve blood swatches?
Completely misstates the testimony.
That is not a proper technique.
Why not?
It's a very hostile environment for any biological material to be placed into, first of all, any plastic bag, particularly when it's wet.
Now, what is the proper procedure in terms of whether blood swatches should be dried right at the scene or dried later?
It's my opinion they should be dried at the scene.
Now, again, with respect to documenting such things as bindles or containers with blood swatches in them, is it important, in your view, that they be initialed by the person who actually does the collection?